Well, good afternoon or good morning, depending on where you're coming from in our great country. Dan Hen, CPA, CTR, coming to you from Rockledge, Florida today. And you are here for what we call CTR 105, also known as the Power of Attorney or Third-Party Authorizations class. And today we'll be talking about everything to do with the Form 8821 and primarily more the 2848 and how we deal with those so that we can get access to clients' information to help represent them in whatever case that we're dealing with. So we got a lot of material to cover, so let's go ahead and get started. So first, this information is copyright protected. This information is as up to date as we know it. And your questions are encouraged, so please just post that into the chat if you have any questions, and I'll do my best to answer your questions. Just please note that we can't handle client case specific questions or issues, so if you can make them a little more generic, I can give you a better generic answer. Okay, so here's the updated slide about me. This is the most recent picture that I have of me and my new grandsons. I still can't believe I can say the word I have grandsons now. This guy is 2.5, and this one is I'll be 6 months old this week. Now, in the course of this 2-hour CPE, and just to let you know that I rarely get this done in the hour and 40 minutes. Usually it takes me almost close to 2 hours to get this CPE class done because there's a lot of material to cover. I'm trying to get this done, although, I probably could almost do a whole nother 2 hours to make a supplement to this class. But we're going to talk about what a taxpayer representative is by the definition of the IRS. When is it that you're a representative that you need a power of attorney? We're going to discuss the authority that gets you that is granted to you as that representative using the power of attorney, or what that gives you when you're an appointee using the taxpayer information authorization. We're going to explain the difference between a representative and appointee. We'll talk about the differences, compare and contrast the 2848 and the 8821. We will then go through the proper way to prepare both of those forms. We'll talk about revoking and withdrawal, what that is and how to ultimately do it. We're going to talk about the various methods now to submit these documents and get that to the IRS. And then we're going to talk about some tips and tricks in regards to these forms and how to deal with it. And then at the end of the day, how do you know what powers of attorney you have outstanding, if any, so that you can know whether or not you should still get rid of something? Okay. So let's talk about where this kind of comes about. We're going to go through some code information to start with. Now, number 9 in the Taxpayer Bill of Rights is that the taxpayer has the right to retain representation. Okay, that's in Internal Revenue Code 7803A3, that every taxpayer is entitled to retain representation, and the taxpayers have the right to be told that if they can't afford to hire one, that they may be eligible for assistance from the low income taxpayer clinic. Now, there is a dollar income threshold that they have to meet in order to get that to qualify for that particular criteria. But uh, that the low income tax, so that's usually law firms who support that, or students of a law school that will usually support the low income taxpayer clinic. And then the third thing that I've really highlighted that's really important here is the taxpayer may authorize a third party to receive their confidential information. So note that it says receive, and so receive and then to communicate back to the IRS, those are two totally different things. Now, under the IRM, and this is actually in the area of the taxpayer advocate where I got this information from. So we've already talked about the 7803A3. And more specifically, when we get into here, looking under Code Section 7521B, this provides that if the taxpayer clearly states to an IRS employee at any time during an interview that the taxpayer wishes to consult with a person who is permitted to represent the person before the IRS, such employee shall suspend the interview. Okay, that's under the law. Okay, I just taught a class recently where I was talking about how that happened with there was a enrolled agent talking to a revenue agent in the IRS's office in cubicle land. And in the next cube over was another revenue agent with a taxpayer. And the taxpayer said to the revenue agent that maybe I should hire a representative. And then the revenue agent said, "Yeah, I don't think you need to do that." I can get and understand where they're coming from. They probably were not far away from getting this done. They didn't want to prolong it, which is what's going to happen if they hire a representative. And it was the wrong thing to say because at that point in time, then they should have just backed off. I make that equivalent to basically in a criminal law case when somebody's taken in for questioning, they've been arrested, then once they've said that they want a lawyer up, they wanted it to be represented by an attorney. I want an attorney. Then the line of questioning is supposed to stop, then that's done. Then by law, if there's any other questions, then generally that information can't be usually submitted under law in the case. So that is a violation and it actually breaks the law. And one thing I can tell you with 100% certainty is all government employees are not allowed to break the law any different than us. So by breaking that law, they could actually lose their jobs if you wanted to pursue that further. So always be mindful of that. Code Section 7521C provides that anyone permitted to represent a taxpayer before the IRS who has a written power of attorney may be authorized to represent the taxpayer in an interview, and that the IRS employee may not require the taxpayer to accompany the representative to such interview in the absence of an administrative summons issued to the taxpayer. So that means that there is absolutely no requirement, it's even in the law that says there's no requirement the taxpayer must be there in any interview, conference, phone call that you have with an IRS employee. Okay, and the only exception to that is if they actually issue an administrative summons and require them to appear, then they are required to be there. Outside of that, there is absolutely no requirement. They will ask, they will ask, and they will ask, and every time your answer should be no. And even if your client wants to, your answer should be no, because more often than not, taxpayers shoot themselves in the foot, and then make your job even harder. Okay, so we don't want to do that because they're hiring you to be their advisor, and your advice should be you are not allowed anywhere near that room. That doesn't mean that they can't be, if you're talking on the phone, that they can't be in the room with you, or that they can't be readily available on the phone, that you can reach out if you had to ask questions. Then, have them, let them know that you're in the conference and that if you had to get a quick answer on something, you can call them and tell them to please be available during that time frame. And then under Code Section 6304A2, provides that the secretary may not communicate with any taxpayer in the matter of the collection of any unpaid tax if there is knowledge that the person has representation, unless the representative fails to respond within a reasonable amount of time, or unless the representative agrees with such direct communication. Okay, so the one case that I talk about this is I had a client who was already in the middle of an exam, and uh, she came to me and said she wanted to hire me. And so I had her sign power of attorney, but I didn't get it over to the revenue agent right away. And so within, I don't know, a few days after our meeting, he ended up calling her. They had a conversation because they've been having conversations, so he never thought anything of it, and they generally don't go back and look that, hey, did she hire somebody? That's not a requirement that they have to look at it. They generally look at it once, and that's it. Unless they have given any other indication that a representative has been hired, then there's no reason for them to look at it unless they say the taxpayer says something. So they got through this whole conversation, and it was at the end of the conversation that she decided to say, "Oh, and I hired, Dan Henn to be my representative." And the revenue agent, I can imagine that when she said that, he probably crapped a brick because it then became the response to me when he talked to me for the first time. He apologized profusely to me that he ended up talking to her, and it was like, he didn't know. I hadn't gotten him the document, so he was doing what he was supposed to do, and I basically gave him some grace, which at the end of the day, that basically built some brownie points with me, and he ended up being a really nice guy, easy to get to work with, and I was able to kind of minimize the damage, and he probably, accepted something that he maybe not should not have necessarily in this case. So there are some things to be said about, playing nicely with others, especially when they're IRS employees. Now, when it comes to the types of third-party authorizations, there are a few ways that this can be done. Now, the first one and the most encompassing one is the power of attorney. You use Form 2848, or please note that you can use some other documentation, as long as it has the requirements of the code, or in this particular section, the Treasury regs. Now, you get to actually step into the shoes of the taxpayers. You actually get to not only get information, but you get to communicate information. And Uh, now, please note that there are some forms of representation where there are some limitations to what can be done. Then we have and we'll talk more about that here as we go through. The tax information authorization is Form 8821, which allows you to inspect or receive information. Okay, so that's the nice thing about it. And it basically, uh, it doesn't allow you to practice before the IRS. Okay, so the tax information authorization basically says you can get the information, but you can't step into the shoes of the taxpayer. Now, there is also what's called oral disclosure consent. And now there's no form for this. It allows you to receive confidential information. And the most common way that this happens is usually it's a client or a prospect who shows up on your doorstep, or they're on the phone with you, and you need to know more information and you'd like to know it right now. So what you can do is call the IRS, and if you can manage to get through quickly, whether it's talking to, say, ACS, calling the 800 1040 line, calling PPS, that with the taxpayer on the phone with you or in the room, you then have them, you talk to the IRS person that answered the phone. Then what will you tell them the whole facts and circumstances, that you don't have power of attorney just yet, and that you have the taxpayer with you. What they will then do is they will ask the taxpayer questions, and as long as they basically vetting the taxpayer, once they vetted them and they meet the criteria, then they will ask them if they have their permission to talk to you on the phone and provide that information. And if they give the positive and say yes, then can act and ask for anything that you want. Now, please note with that a few things with that oral disclosure consent. One, if you ask for transcripts, please note that they are going to go to the taxpayer's address, and it's the address of record. So whatever the most recent record is, if they've moved, then you're not going to want to do that. So just make sure that they have the current address on file. Second thing is that once you hang up the phone, that's it, you're done, your authority is over. Okay, so now you need to really get the document filed, or you have to go through that whole process again. And I try not to have clients on the phone with me when I talk to the IRS. Okay, I'd rather them hear it from me than hear from the IRS in terms of everything that's going on. Now you have the third party designee. That's obviously a checkbox on the 1040 or certain other tax returns. This gives you some limited authority, but it's only on that tax return, and it's only good for the year after the due date of the return. So, we just filed 24 returns that were due on April 15th. So you have up until April 15th of 26 in which to have that authority on a return for 24 that's been filed. And you can then provide certain information or get certain information on that return. And then lastly, for fiduciaries, that's a trustee, executor, administrator, receiver, guardian. In those particular situations that you get You have to use Form 56 to get that authority. And if you want to get power of attorney, you not only have to file Form 56, but you also have to attach Form 56 to that power of attorney along with the death certificate. And what it does is it gives that the fiduciary to get notices and information related to whatever that situation is. If it's a trust or a deceased individual or a guardian of an individual is the most common situation. Now, again, just to reiterate that a 2848 allows the person to represent a taxpayer, where the 8821 only allows them to get information. Now, the information here in regard to this particular section that I've highlighted in yellow, that the a revenue officer is not supposed to get a power of attorney from somebody who is not a licensed individual, or I should say an unlicensed individual. Okay, so it's a basically a against the rules type of situation. Although, like I said, I've said many times, there are many situations where people get and accept that even though they're not supposed to. Okay, because I've talked to many of a unenrolled tax professional who says that they've talked to people. Now, here's the differences between the 8821 and the 2848. Okay, so on the 8821, again, it can be an individual or a business that is the representative. So here you can put your firm on there, and I've done this before. Now, just please note that if you do that, so this is you put the 8821 in place just to get information, where it doesn't provide as much risk as a 2848. So if you have a client who's come to you, something doesn't seem to kind of add up in how they're communicating to you, and you want to get the information, you can use the 8821. And the 8821 allows your unlicensed staff, it allows your admin person to call the IRS to go and request copies of transcripts. Okay, so if you've got that, you don't have access to it in the system yet, you can use the 8821 to have that, but please note that they're going to want to talk to you and vet you first if you've used the firm name on there. No different than we just talked with the oral disclosure authorization. And then they ask if it's okay to for them to talk to the person who was on the phone, and then yes, you give them the permission so that they can go get that information. Now, again, you can inspect tax information, you can receive tax information, but you cannot negotiate or advocate on behalf of the taxpayer. So basically what that means is you can get information, you cannot give information. You cannot sign any waivers, consents, or anything on behalf of the taxpayer, and you can't redelegate this authority. So once you've gotten this authority, you cannot say, "Hey, I want to pass this on to somebody other than the situation I just talked about from an oral perspective." You can't add somebody else, like you can't add another person to the 8821 if you got a new employee, let's say. Now, compare that to the power of attorney form 2848. This can only be individuals who are the representative, although obviously the person, being represented can be anybody. You may inspect information, you may receive information, so it means you can look at it, you can get it, and now you can negotiate or advocate on behalf of the taxpayer. So again, you get to be the taxpayer. You can actually sign waivers and consents on behalf of the taxpayer. We'll talk a little bit about some of that as we go through on what I would recommend that you can sign, you should sign, or you should never sign. Now, the one other nice thing here is that you can actually delegate this authority. We'll talk more about that later as we go through when we look at the Form 2848 in detail. Now, what is considered practice before the IRS? So practice in front of the IRS is corresponding and communicating. It's representing the taxpayer at conferences, hearings, meetings. It's advocating for the taxpayer and disputing proposed adjustments, preparing filing documents with the IRS on behalf of the taxpayer, and rendering written advice. Okay, so ultimately at the end of the day, it's looked at as uh, basically any kind of representation as well as anything related to uh, kind of advice that you're giving, especially written advice. So if you've written a basically a research memo on a particular issue, then that is considered practice before the IRS. Unfortunately, preparation of a tax return is not considered practice before the IRS. Hence, you don't need to be a representative or anything at this point in time, at least not as of today. There's still hope that Congress will change that and give the IRS some authority to uh, put more on those that are unlicensed professionals out there who kind of give it a little bad name. I'm not saying that the bulk of people are there, but that there are a lot of people who are unlicensed professionals who prepare returns that shouldn't be. Now, when you're talking about an exam, this is a little more in depth, and I don't have a separate slide, but I'll compare and contrast this from an exam perspective versus a collections perspective. Now, with the power of attorney, you can practice anywhere in the country, and so obviously that's a good thing. Now, when it comes to the items in blue, those are the good things, and the items in yellow are basically things that you should stay away from. Absolutely 100% stay away from. So you shouldn't sign any returns. I never recommend signing returns. There are some limited situations in which you can, but I don't recommend it. And you're not supposed to, well, you can receive a refund check, but you can't negotiate it. It means you can't set it up to go be deposited, whether it's your account or their account. So I just get in the habit of not signing tax returns. I've never signed a client return for a client, and I've never received on their behalf a check. I've gotten a check by the taxpayer giving it to me, but I'm usually sending it back in those situations. Now, all the other items in blue, those are items in which we need to then discuss a little bit. So it says you can sign consents, report waivers, and claim disallowance reports. While you can, I don't recommend signing those. Now, you can represent in appeals, and I recommend that you sign letters and documents that get you to appeals. Okay, now please note that, and this is on the exam or collection side, that you can sign those. Just be mindful that some of them are signed under penalties of perjury, and I'm usually not concerned with that because obviously everything I put down there is going to be truthful in terms of the situation. You can file a written response to a 30-day letter on an exam, and I would sign that. You can receive, inspect confidential information. If the appropriate box, you may receive notices and correspondence, and I usually recommend that the first person on the line, yes. The second person on the line, if you have more than one person, then yes, you should receive those notices. You can discuss proposed examination adjustments with the IRS personnel. And again, I recommend that you do that. You can negotiate with the IRS on behalf of the taxpayer. Obviously, you're going to do that. You can advocate the taxpayer's position to the IRS officials or employees. Again, you're going to do that. Offer or execute a waiver of restriction on assessment or collection of deficiency in a tax. Okay, so basically you can sign that notice of deficiency. I would never do that. To be honest with you, you should never do that. Could you? Yes. In some limited situations, you maybe like a no change or whatever, then you're good there. But if it's anything that shows an assessment and additional amount due, if anybody's going to sign that, it really needs to be the taxpayer. You can sign an offer or execute a waiver of notice of claim disallowance. Same situation. I don't recommend you sign those, but the taxpayer should. You can also execute a consent to extend the period of assessment or collection of tax. Now, collections are usually rare in which that would ever be asked for. It's most common in an assessment situation. So, because they only have 3 years in which to make that assessment, and it's very common that that period needs to be extended. I would sign that, but I would make sure that I have something in writing that says that the client taxpayer agrees to extend it. okay, and they're giving you permission to sign that. And then you can execute a closing agreement, but again, that would also be something I would not sign. Now, again, things that you can do with power of attorney, you can record an interview, okay, and I've talked about that before. When it comes to recording an interview, it's something that you shouldn't, I wouldn't recommend doing. And the limited situations where I would recommend it is if you have got a belligerent revenue agent, revenue officer, somebody who is just being stick in the mud, the biggest wicked witch of the West, whatever you want to call it. Then they tell you one thing and they do something else. Then get that documentation so that they're going to mind their P's and Q's and make sure they give you the information. Now, from the collections perspective, that signing an 843, I would sign that. I would sign a 12153. I'd sign a 9423. Those are appeals related things, but I wouldn't recommend signing the 656 for the offer on compromise, the 433 of any version of that form, whether it's the A, B, the F, the OIC, the D, the H. I would not sign any of those versions of the form. Okay, that is for the taxpayer to sign. And like I said, signing the extension as long as you have documentation to prove that it's okay for you to sign that. Okay, and again, when you get that power of attorney in place, let them know that they're no longer to talk to the IRS, nor should they call the IRS even in the process, even if they think that they want to explain anything. And then I would probably put some kind of penalty in there if they do. Okay, because that can derail, kill your case. Okay, now when you submit the power of attorney, you're submitting that to the CAF unit. That stands for the centralized authorization file. Okay, so this is where all the records for that, the 8821s, the 2848s, all go there. And they have people who are processing those. Now, we'll talk about here later, but I highly recommend that nowadays, if you're going to submit either of those forms, try to do them electronically through your Tax Pro online account. And I'll talk about the pros and the cons as we get to that later. Now, give me a yes or yes if you're ready to move forward. Let's look at the 8821. Last I checked, the forms for the forms for the 8821 and the 2848 have not changed, and they haven't been updated since January of 21. So I just double checked. I forgot to check that earlier. They occasionally update these forms, and now it's about over 4 years since they last updated these forms. Okay. So let's look at the form 8821. Again, make sure that you're using the current revision date. Just, the best thing is to Google it and look at the current forms, and it'll tell you what the most recent version date is. And make sure that that matches if you use a software. So if you prepare it in a resolution software like I use IRS Solutions, or if you use a tax software like I use UltraTax, make sure that it's the current revision because they can reject it if it's not the current version. And that just makes the case that you're dealing with, the representation, take that much longer. Okay. Now we're going to go through some of these various areas in terms of the different items you see uh, circled on the form there on the screen. Okay. Oop, wrong way. So 21. And well, I don't have the detail. So the key is are the items that I've circled, or circled. So the first thing is obviously the revision date. Two is the taxpayer information. This the second item. The third item is the designee or the appointee in this case, which is where I told you earlier can be you as the individual or your firm name. And you fill this out. Obviously, many of you are probably familiar with this from the 2848 perspective. And then where it says new, obviously you're going to mark those boxes if it applies. And I always do the first 5, 10, where I will mark that as new. until I've verified that that information has changed. And you're allowed to put up to 2 people here. And then the other piece here is if you want them to receive notices, you're going to check that box. And then this other one here on number 3 is with the red circle or oval that if you use an intermediate service provider, so if that it means you're using one of the resolution softwares, I call them, so like IRS Solutions and an intermediate service provider, if you're using somebody else to pull transcripts, which somebody like TaxDome allows you to pull transcripts, and you need to make sure you check that box. Okay, most people don't know what the intermediate service provider is, but that's what that is, and you can explain it to them. And then lastly is the blue square is filling this out. Now I'm going to go into greater detail because all of that aligns with the Form 2848. And I'll tell you if there's any discrepancies or differences. But for everything that I'm telling you on the 2848, all of that is going to apply there. Bob says if you use your company on the 8821, the CAF, the P10 doesn't apply. Actually, the P10 doesn't apply, but the CAF number does. So you would not put your personal CAF number. You would actually need to get a CAF number for your firm. Okay, and you just the first time you do it, just leave it blank, and they should issue your firm a CAF number. Okay. Now again, this basically lets you have access to information. Okay, and this is, like I said here, it's best used when you want to access the taxpayer's information, but you're unsure if you want to fully take that client on. There's something that gives you some concern that you might have trust issues on this client or prospect, or there's integrity issues. Okay, so this allows you to pull information and you don't have the same risk as the 2848, and we'll talk more about what that risk is in a little bit. I'm going to kind of skip through this slide. A lot of this is duplicate information. A few additional things here to be aware of. One, um, when it comes to having the taxpayer, if they're sitting there across the desk from you, make sure, have them review the form, make sure that everything you've prepared is correct. Because occasionally I've mistyped a social security number, I've mistyped an address, I've misspelled their name. That all has to be correct and aligned correctly. And make sure that they sign in the appropriate spot, that they date it in the appropriate spot, and then you get to countersign and date before you get it to the IRS. Because if it's missing any of those things, if any of those things are out of alignment, it's just going to hose up the whole process, and it makes everything take longer when you're trying to represent a taxpayer and you want to get access to that information as quickly as you can. Okay, next thing. They changed this process. I think I want to say it was about 2018 that they started requiring a power of attorney for each separate person for the couple. So if it was Mr. and Miss Jones, then Mr. and Miss Jones used to be a attorney, and they both sign it. As of 2018, I think it was January 2018, they said that no longer can then you do that. Each person now has to have their own individual power of attorney. Also, these forms terminate on the death, incapacity, or incompetence of the taxpayer. So once that has been determined, your power of attorney is no longer good. Okay, and so be careful that if you know that they're now deceased or incompetent, that you can no longer you should no longer be pulling transcripts. Okay, because you don't want that ever to come back to bite you on there. I've never seen anybody challenged on that, but it could be because you've now improperly accessed their information. Now, please notice this is another side note is that if a taxpayer dies and you've got an offer in compromise in process, that also kills an offer in compromise. If the taxpayer has a durable power of attorney that allows, and the durable power of attorney has to allow for them to sign a power of attorney. Okay, so meaning that they can deal with the taxes aspect is usually what it says. So if they've been deemed incompetent or incapacitated, then that durable power of attorney should accompany your 2848 as when you submit it. Okay. Now, if the taxpayer dies, then you should submit the death certificate along with a Form 56 for whoever's handling the state or the deceased person's affairs subsequent to that. Now, ensure that the power of attorney that has you authorized to receive that taxpayer data on all modules, years you need. Now, I'll talk a little bit about this one, and I'll show you where it goes on the forms. So, for example, if you're looking for first-time penalty abatement, if they qualify, then you need to make sure you have enough years. Okay, the IRS is technically not allowed to communicate any information to you that you're not authorized to get. So I have had some nice revenue, or excuse me, IRS employees where I'm trying to get information and I get the information and let's say I only did a year or like 5 years worth of information. And I've had a few of them where they were like, hey, there's an issue with another prior year. That's as far as they usually will tell me. They can't tell me what year. So then I've just gotten more into the habit of it's pretty standard for me that I will go back to a minimum of 2010. And in most cases, I usually will go back to the year 2000. And some people will question that, oh, you don't need to go that far back. And I just explain to them that I want to look at that. I just want to make sure there are no other issues so that we don't have to keep completing and filling out a new Form 2848. So it makes it quicker and easier for you to access that. And when it comes to the future, the IRS won't let you put more than 3 years to the future. Okay, so I got to fix that. The autocorrect did that. So if it should say if the 25, if it's the current year, then you can go out to actually to 2028. Okay, so you can put that there. Now, if you put more than that, they're not going to input into the system more than 3 years in the future. Now, the filing of a new 2848 supersedes any 2848 that exists. I'll check the uh, box 6 on the form 48 in a minute. The filing of a 2848 will not revoke an 8821 or vice versa. And do not remit the 2848 with a new page 1 because they're a 2-page form. The signature is on the back. There is no signature or handwriting on the front. It is very easy, and I've known people who have done that. Please note that they're not supposed to accept those submissions, and if for any reason because the dates, if they get too stale, meaning getting old, then they generally won't accept that. So just be careful. Again, that can come back to bite you from an integrity issue. And then lastly is, as I mentioned, if this is the first time you're filing the 8821 or 2848, you don't have a CAF number, just leave the CAF number blank. But please note that you can now request a CAF number directly through your TaxPro online account. So if you want to do it there. Now, if a tax return preparer uh, calls to make an appointment, discuss a case, and they don't have a 2848, they're not supposed to give you any information, including acknowledging that an exam is in process. Okay, so don't try to call them and see if you can get information without having either the taxpayer with you or that you already have the 2848 that you can send directly to them while you're on the call. Okay, or fax in advance and then call an hour or two or day later. Okay. Okay, so now let's get into the 2848. So give me that you're awake and we'll give me the yes or yes, and we'll go ahead and move forward with that. Okay, great. Thank you. Again, latest version of this form is January 21, and a few things to make sure that you're aware of. Okay, so whether you're hearing this live, you're hearing it on the recording later, you need to have an ID.me account. By now, hopefully all tax professionals have one, but just on the off chance that you're a newer tax professional, you don't have an ID.me account, you need to make sure that you have one so that you can access it. It allows you to access your e-services account, your Tax Pro online, your Taxpayer online, your business online account, and get that information. Now, I highly, highly recommend that all tax professionals communicate and start getting all of your clients to get that ID.me account. You'll find out a little bit later when we get to the end in submitting or getting access to clients' information that it's in their best interest that they start getting that now so that they have it if they ever need it. And it makes it quicker access, and especially in light of the current environment that there are fewer and fewer employees at the IRS. They're supposed to be losing at least 25% of their employee workforce here in the next few months, and it wouldn't surprise me if it goes even further. They were just over 100,000 employees not that long ago, and it wouldn't surprise me if they get down to 50. When even with the last administration, there were at the lowest point, I think, was somewhere in the 80s. That's the lowest number of employees, 80,000 that they've had in a long time. There's been as many as 120 or 130,000 employees in the IRS. So they had already gotten to be kind of lean and staffed up to help enforce, do a lot of the different things that they were doing at that point in time. Okay, so the having the ability to do it yourself and access that information is going to come in a lot more handy in the years to come. Now here's the 2848. It's a 2-page form as opposed to the 8821, which is a 1-page form. And we're going to go through here line by line here over the next few slides. So again, check the revision date. Make sure that's the accurate one that you're using in whatever software that you're using. And we're going to go through these first two parts, part 1 and part 2, and what goes on these respective lines. Now, part 1, question 1 is the taxpayer. So what goes here? So if it's an individual, you put their name, address, or whatever their tax ID number. Remember, each spouse must submit one on their own. Legally, a power of attorney dies. And like I said, it could be an ethics problem, and you don't want to get caught in that if you uh, continue to pull information, call the IRS, and because the IRS isn't going to know right away if they're deceased. So if you call up and you now knowingly know that they're deceased, that your power of attorney dies when they die. Same thing for a durable power of attorney. Now, if it's a corporation partnership, it's the name, address, EIN. If you have consolidated returns, it's the parent who files, and then you attach a separate document showing the subsidiaries, the EINs, and the names of the companies, the same information. If it's an exempt organization, same name, address, EIN. If it's a trust, name, address, EIN of the trust, as well as the name, address, social, and title of the trustee, fiduciary involved. If it's a deceased person, it's their name, address, social of the decedent, as well as the name, title, and address of the executor or personal representative. If it's an estate, then it's the name of the decedent and the name, address, title of the executor or personal representative. If there's no estate created, then just use the social security of the decedent. Okay, so this would be the estate of Joe Smith. Or the Joe Smith estate is usually how it's worded. Now, if it's a gift tax, it's name, address, social of the donor. And if it's an employee plan, it's the name, address, the EIN, or social security number of the plan sponsor. So if it's a sole plan sponsor, then you would use the social security number. Now, so that's this first top information that we're looking at here. So let's talk about then part 2. Part 1, question 2 is the representative. So what goes here? It's the name and address of each eligible representative. So remember here, so see how it's got now, this used to have 3 spaces. They did add it, I want to say a couple slightly prior to 21, they added a 4th field for a 4th representative. But please note that they only allow for sending copies of notices to the first 2. So I've seen it where sometimes if you've got multiple offices, you'll have somebody here in office A and then somebody else here in office B. Because if people in both offices can handle cases, then both offices are getting those notices. Okay, so that people can be aware of that. Let's see here. So you're going to enter the CAF number and the PTIN, and if you don't have either one of those, then you put applied for or you leave it blank. Okay, so you put the telephone and the fax number of the representative. If you don't have a CAF number, leave it blank. They will assign one. then we recommend getting a new CAF number if you've left an employer to start anew. So it's happened. I know Jason Bowman, this happened to him, my former partner in the Tax Resolution Academy. And Jason left his employer, and because he was one of a few people who had power of attorney. It was a guy. They had another guy that wasn't licensed that played him and called the IRS. Had this happen to another member of ours, where she was since it was a woman, they did that, and they had somebody play her. So let the IRS know that you should cancel that CAF number and get a new CAF number so you can start fresh with that. Again, most people like to get a new CAF number for different locations. Please note that the IRS typically doesn't like that, but many people do it and can get away with it. They will not assign CAF numbers for employee plan status or exempt organization application requests. Now, a government employee who has left the IRS, especially in Treasury or IRS, they're prohibited from working on cases in which they were involved. Okay. But the and if there are more representatives, you're allowed to have more than just the four. You just write "see attached" in one of and probably usually in that last space. So if you had six people, you can have six people, but no, the first two are only going to get the notices. Again, mark the box for change of address if that occurs, and I usually do that for the first 5 or 10 that I do after that. And then we talked about the notice representatives there. Which then brings us to part three or question. Let's call it. Actually, no, it's because see, this is part one, question two. So then we go to part one, question three, acts authorize. So what do we put in here? On the screen is an example of some things that you can put. This is not necessarily meant to be an all-inclusive list, but this is a very comprehensive list that I've done some research and found anything that you can actually put on that line. The most common ones that you're going to come across is income, payroll, or employment. Okay, those are the two most common ones. Outside of that, you're going to put excise, estate, trust, gift. Outside of that, trust fund recovery penalty, innocent spouse relief, FOIA request, civil penalty, certain penalties like the trust fund recovery penalty. If you get into the health insurance penalty, the 5,000A is the individual one, and the 4980 is the employer side of that. If you're doing the entity selection or S Corp, the 8832 or 2553. FBAR, Voluntary Classification Settlement Program, and separate assessment. Separate assessment, that is when you have a husband and wife situation where they're no longer married, or trust fund recovery penalty where the trust fund recovery penalty has been assessed. That same trust fund penalty has been assessed to multiple people. Now, this is the first column, so the description matter. So the other two columns is the form number and the years or periods. So here are some examples of what you would put in. So 1040. So that would be income 1040, and then you put the year that's involved or years. You can put and typically when it comes to the payroll ones, I would typically do it like this: 940, 941, 944, 945 if it's applicable. Now, because there's limited number of lines, a lot of times I would put all of these, including the W2, W3, and I'd put that on the employment or payroll line. I would issue a lot of these different ones. If you're dealing with the proposed assessment of the trust fund recovery penalty, 2553. So those are the common ones that I would put on here. In terms of periods, you can put a single year. You can put a range of years doing it this way. You can put a range of years doing it this way. Now, if you're putting it like this, Q1 to Q4, then that is typically looked at as, first quarter of 12 through fourth quarter of 14. Now, you can put years like this. So if you don't need every year, you can put, say in this case, we're doing the odd years. Now, fiscal year would put them in this form. Okay, so it's being whatever their fiscal year end is in the range. You can put just years through this. So as opposed to the hyphen, you use the word through. And if you are doing it, so if you're doing it sometimes payroll related by quarter, so if you wanted specific quarters, you can list these particular quarters, or you can put it this way and get a range of quarters. And whatever you do, do not put all periods or all future periods. That is terms for it automatically to be rejected and sent back to you. Okay, now if for whatever reason a field doesn't apply, then use, the NA or N/A in a field, because there are certain things where they're not year specific. Something like a 2553. Well, actually, no, that is year specific. Um, there are certain items where there could be where they're like a civil penalty. A civil penalty might not actually not I take that back. Not year specific. A civil penalty might not have a form number associated with it. Okay, you're more likely to not have a form associated with something in a particular issue that we just talked about here on this area. So the 5000A, the 4980s, a FOIA, those aren't going to have form numbers, so just leave that space blank. Now, a few tips in regards to this. In an exam, be sure to include all the open years. I talk about that. So make sure you do that. And I'd probably even go further back. Like I said, go back to the year 2000 in terms of that, just so that you can see whether or not there are other outstanding liabilities. If there are, if they have the opportunity first time penalty abate, you're going to want to look and make sure that you have that. And you should revoke or withdraw a power of attorney or 8821 if the case is completed, and I'll talk more about that when we get to that later. Well, it takes us to question 4, specific use not recorded on the CAF. Now, there are certain items where you need the power of attorney, but it's not recorded on the CAF unit. So in those particular situations, these are some of the examples in which you can use that for. Okay, so usually you have the document, but you're not sending it to the CAF unit at the end of the day. So that could be a FOIA request, a private letter ruling. It could be related to the trust fund recovery penalty, change of accounting. If you're trying to apply for an EIN, you do not need to submit that, but you need to have it in your hands that you have the authority from the taxpayer. If they ever question it, I've never seen them question that, but it could be possible. If you're trying to apply for an ITIN with the W-7, or the 4361 for clergy for the exemption of paying the self-employment tax. Okay, so these are all some of the examples that you could use there. Question 5A, additional acts authorized. Now we're going to go through all of these check boxes and what they mean, and I've got a few different slides on that. So the first one, I mentioned this earlier when we looked at the 8821. Now this was a question that came about, I think it was in 2018. I actually had somebody when I was teaching a class, I think I was in Austin, Texas, and somebody had told me, actually it was 2017, they had told me that they had called the IRS and they were using a software. At the time, it was a different software. So something like, again, IRS Solutions to be able to pull transcripts. And they found that this person was using it, and there was I never saw anything, never heard anything. Shortly thereafter, this question popped up. So if you use the IRS Solutions Canopy Pitbull, Tax Help Software, IRS Logics, Tax Dome, or anything else that allows you to pull transcripts, you need to make sure you mark that box. Make sure that the client signs that when you do that. Okay, because technically you're not allowed to use it if that box is not checked. Okay, so that should be a default answer that question. I always make sure I check that box. Now, the next one is authorized disclosure to third parties. I never personally ever want to do that. Okay. If anything needs to be disclosed to a third party, then I give it to my client and that's their problem. Okay. So if a bank, if a mortgage broker, if anybody is asking for a return or any other information, then here's the information, you get it to them. Now, if I put it in my secure portal and they want to give their login information for them to go download it, that's up to them. Okay. I didn't give them that. I didn't disclose it directly to them, nor did I give that information to them. The next one, substitute or add a representative. I always mark that box because I always want to have the ability that if I add a new employee, or maybe I have an existing employee that's going through exam prep, they're going to become a enrolled agent, a CPA, whatever, then I want to mark that box and be able to add them easily to it. Now, what you have to do is you still have to prepare a new power of attorney. You have to prepare the power of attorney with their information on it. But what you do is then you also add that you're going to add the box there, and then what you're going to do is you're going to attach the old power of attorney with the new power of attorney, and that so basically it's showing that the taxpayer gave you authority to add an additional person. Okay, and so then that additional person will be added to that, and it's just a nice, I'll call it luxury to be able to have, so that if you add an employee, which you should have somebody that can help you with these cases, because you're the more knowledge and experienced person. You shouldn't be in the weeds pulling transcripts and doing preliminary analysis and pulling all of these things. That should be somebody else's job. That's what you would pay them for. Okay, now we're going to continue on. As you can see, there's a few extra boxes here. So we covered the first three. We're going to go cover these last two in this area. So, authority to sign a return. Now, these are the two areas where you need to be mindful of this. One, you do have authority to sign a return if the client has given you permission, which you can do on the power of attorney, and it's in these limited situations. Okay? If they get you're given permission to sign the return on behalf of somebody else, if there is a disease or injury, if there's a continuous absence from the U.S., including absence from Puerto Rico for a period of at least 60 days prior to the date required by law for filing that return, or C, specific permission is requested and granted by the IRS for other good cause, they may grant it to a representative or another agent. Okay, now my personal take on this is I would never sign it, because if you sign a return, you are now the person signing under penalties of perjury and that you agree to whatever on that return. So I just never would, even if it was my mother or brother, I would never really trust that person 100%. And I would highly recommend that you don't sign or ever get authority to sign on that, in that case. Okay. Now, if you are if they are authorizing the representative, they have to check the box, and then they have to include this statement, in there, that this power of attorney is being filed pursuant to this section, which requires a power of attorney to be attached to a return if a return is signed by an agent by reason of, and for whatever reason that you're giving one of these above. Okay, so you would have them sign the power of attorney in advance, then you would attach that power of attorney to the tax return in which you are signing, if that were the case. Again, I don't recommend you do that, but it is a possibility. Um, okay. Now, in fact, I'll come back to your question here in a second, Bob. Now, next part is 5B, specific acts not authorized. So what happens here is the taxpayer can say, I don't want you to do this, that, and the other. So some examples are, they don't want you to sign an ASET or CSET extension. They don't want you to sign a form to go to appeals. They don't want you to sign the form 433A or B. They don't want you to uh, specifically endorse or negotiate a check, even though you're technically prohibited from negotiating or endorsing a check. But any or all of these things, they don't want you to do a FOIA request. They don't want you to get an EIN. So, I've never come across anybody that ever says they don't want that, but that there is a spot there that they can say, hey, I don't want you to do this, that, and the other. Now, your question, Bob, authorized disclosure to third party. Getting authority to disclose something to, like, for example, husband and wife. If you know that they're going through separation or divorce, disclosing the husband's information to the wife is a third party disclosure. Disclosing information to a child or a parent, disclosing information to the a business partner on a business that you normally deal with one partner and another partner calls to get information. Even though they have the right to get it, then you really need to make sure you confirm with the person you normally deal with. Giving information to a mortgage broker, to a banker, to a financial advisor, those are outside third parties that they need to give you permission to do that. I never ever want to give that information. Now, outside of the Form 2848, if you don't use that, you need to get a 7216 uh, disclosure letter that allows you to do that information alternatively. If you don't get the power of attorney, then you get the 7216 disclosure. And again, I just never did that. I used to do that, and then I just realized it was more hassle than it was worth to get the proper letter to that meets the correct criteria of the 7216. And I just said, here's the information, you can give it to them. Okay, it wasn't me. Takes us to question 6, retention revocation of a prior power of attorney. Now, if the IRS records the power of attorney in a CAF system, it will generally revoke any earlier power of attorney on the power of attorney, so or on the system. So if you're filing a power of attorney, if there was another previous power of attorney, that's just going to kill whoever else was there. Okay, so if there was another power of attorney, so like the good example why you might not to want to have that happen is, let's say a licensed tax professional that you work with or know was working on a case. And when they work on that case, they feel like that it's finally gotten over their head and they've talked to you and you find out that it's something you can handle. So you want to maintain their current power of attorney without having to put a new power of attorney in place with both your names on, although you could do that. You could leave their power of attorney in place and just make sure that the box is checked that you're not going to revoke the earlier power of attorney. Okay, so that's one example. Second example is there you previously provided IRS Office of Chief Counsel with a power of attorney authorizing Attorney A to represent a private letter ruling. Now, several months later, you decide you want to have power attorney Attorney B handle the matter. So you put a new document together, adding party B, and then leave that in place. So that's another example. Okay, and if you do not want to revoke it, check the box and attach a copy of the original power of attorney. So it goes along the same lines when you're adding another person to it. Because again, if you do that, if you don't do that, then they don't know who is they don't know who the person to get rid of is, or to keep, I should say. And then remember that if you file a 2848 and then you later do an 8821 or vice versa, that doesn't remove the prior one. Part 7 is the signatures of the taxpayer. So here, individuals sign. I'm not gonna go into this just for the sake of time in too greater detail because we still have a lot of material to cover. But at the end of the day, the individual signs. You can't have a spouse sign for the other unless they have durable power of attorney. A individual under 18 cannot sign this. They have to have the parent or court-appointed guardian sign it. You should include court documents showing that this person has that authority. And if outside of that, let's see here. Other individuals may sign for the taxpayer if they have the 2848 that has been signed by the parent or court-appointed guardian, authorizing them to sign, or, like I said, durable power of attorney. In the business sense, a corporation or association, an officer with legal authority must sign, and they have to have legal authority to bind the corporation. Partnerships, same thing. that you need to include the name and title of the person. Estates, only one, if there's one more than executor, only one co-executor has the authority to assign. Employee plans, that person who is the fiduciary of that plan, and any others if the taxpayer is a dissolved corporation, deceased individual, insolvent, so there's a bankruptcy trustee involved, or a person for whom or by a fiduciary is going to sign, then that person needs to sign. And in cases of deceased or when they're representing somebody else, you should have a Form 56 filed with the IRS as well as included in with a copy of the 2848. Now, please note that the IRS does accept electronic signatures or digital signatures. I still am of the authority that you should still get the wet ink because there are still some people at the IRS that won't accept them, and technically the IRM does not allow them to, so they're well within their rights. But I like to get the wet ink signature if I'm going to do it on paper. Now, having said that, we'll talk here more about the digital ways to actual do it to get access, and you still need to be careful there, and we'll talk about that here in a minute. And lastly, we come to part two, is the Declaration of Representative. Okay, now when it comes to the authorized representative, I'm really going to only focus on the first three. So if the licensed tax professionals here, attorneys enter the two-letter state that gives them their license. Same thing for CPAs. Then you put in for attorneys, you put their bar or practice number or their license number. Same thing for CPAs. And you include, so that would be, so in this space here, so you can see here where it says the designation code, their licensing jurisdiction, and then their bar license number. Okay, so that's what goes there. For enrolled agents, you put your license number, your enrollment card number. I forget. I think it's one of those that also has a lot of zeros. So please include, all the whole thing, whatever's on your card, including any zeros that are there. It might seem like, like if you were, you had card 100 and it had five zeros in front of it. You put the five zeros and the 100 in there. Okay. And then outside of that, then, titles, positions, and if there is the ability here for, if it's a qualifying student, they have to be in a low income taxpayer clinic, unenrolled preparers put their P10, and so on and so forth. Now, unenrolled return preparers may not represent cases before appeals, before revenue officers, IRS chief counsel, or any similar officers. Okay, they can't do for tax returns and claims for refund signed before January of 16, then they're limited to just the exam. After that date, then they have to be an AFSP in order to handle the representation of the case. And yes, Bob, so in terms of preparers, you're as an EA, you put the EA in the whole thing. So whatever's on your card, that's what what you should use. Now, when it comes to the date, please note that it might seem inconsequential about the date, but it is very important. So pay attention to this. What I generally do is have the taxpayer sign first. They're granting the authority, then I sign it. Now, in the situation for domestic authorizations, meaning that the taxpayer is here in the US, the representative must sign within 45 days from the date the taxpayer signed. So if they sign first, it's 60 days if the taxpayer is out of the country. Now, if the representative signs first, then the taxpayer does not have a required time limit. So I usually will have them sign first, and then I will sign next. And you need to pay attention to that because if that date does exceed that, they do cancel it and terminate it. Okay, or they won't to put it in place. Okay, and they won't accept a cat. So if for whatever reason you received a power of attorney and somehow it didn't get remitted to the IRS, if it's older than 120 days, they generally don't accept them. So do pay attention to that. Now, a few other considerations, things like the single member LLC. Single member LLCs are disregarded for federal tax purposes except for employment tax. So if you have a single member LLC and they are filing payroll returns with an EIN, then put that EIN on there. If the business activity is reported on a 1040, that is for the individual. Spouses cannot sign on behalf of that. So if you have a Schedule C that has payroll or Schedule E, then they need to have a separate type of a power of attorney that will give the spouse that authority. If it's signed by the individual member, it should include their Social Security. And if one exists for employment or excise tax purposes, use the EIN. And if it's a business activity for a 1041, that's usually attached to a trust or estate, then the trustee, executor, or fiduciary responsible would sign that, and you must include the Form 56 there. In the military sense, there is what's called a military power of attorney. So if you have if you're trying to represent a military couple, and one of them is out of the country, serving in our military, then this military power of attorney does allow for the spouse to sign on behalf of the other spouse that's out of the country serving. And so you need to get a copy of that and attach that to the 2848 as well. Okay. And just so you know, and anytime that somebody is signing on behalf of somebody else, it should be they sign their name as POA or as trustee or whatever their connection relationship to the person they're signing for. So it would be Joe Smith signing as military power of attorney, and you can abbreviate MPOA. Military power of attorney for Sally Jones, let's say. So that would be durable power of attorney, whatever it is that you're using. Okay. Now, here we're going to start talking about the ways in which we can remit the Form 8821 or 2848 to the IRS. Now, the old traditional way was we mailed it. That's how we used to do it when I first started handling cases. I've done power of attorney for decades now. And we used to mail it. Then fax is becoming more popular, so we started faxing them over. Now, from this perspective, the slowest way you're going to get there is the mail. If you're not digitally inclined, then the fax is probably the next best way. Because then from here, we have other digital online ways that you can do it. Now, please note that it says there, if you live in these states, send to here. So here I'm in Florida, I send to Memphis. Bob, you're in Arizona, you send it to Ogden. But please note that if you mail or fax, so if Bob, you mailed it to or faxed it to Memphis, they're required to accept it. It's not a grounds for rejecting it. So and I have done it many times where I've heard Ogden was processing them faster, then I've done that. I send them to Ogden and they still process them. So occasionally that happens. I haven't faxed in quite a while because I typically do online nowadays. Now, in January of 21, the IRS released a new tool called the 2848 8821 online. And in July of 21, that's when they first created the Tax Pro account. We'll talk about that in terms of how then um, how you can access that. Now, let's do a little compare and contrast between the two. One, if you use the 2848 8821 online, there they can accept wet and electronic signatures. But what I always point out is that sometimes when you're dealing PPS with the Practitioner Priorities Support Line or ACS, the Automated Collection Service, there are some people that won't accept an electronic signature. Okay, so if they don't accept it, then you have to hang up and call back and talk to somebody else. Sometimes it's not everybody. It's some people stick to the rule and some people don't. Usually, I think they're newer employees when they don't. Now, on the 2848 online, what gives the authorization is actually signing and dating the form. Okay, and so and it goes with whether they fax it or mail it or scan it. It doesn't actually have to be the wet paper that they give you, the one they actually put the signature to it. This can be used for individuals and businesses. It is the access point for the representative. You do get basically you're going through the e-services to log in and upload the document. They ask you a few questions. So, and I'll talk about that here in a second. It generally is taking 1 to 2 weeks, although I had one recently that took a whole month to process. I don't know why, but I did one recently where it took a couple of weeks, and I did another one here just recently that was less than a week to get that up to for me to be able to access transcripts. Now, they do ask you a few questions. One, was it handled in a remote transaction? So if you're doing things over the phone or through a Zoom, you need to make sure that you get the documents. I would recommend getting their driver's license and a social security card, or at least something that has their social security number on it that you can verify that they are who they say they are, and you should do at least some kind of video conference to verify that they are who they say they are on their ID. Because unfortunately, it's so easy to doctor create information. I can only imagine that there's people out there now starting to. I've seen people fraudulently start to create now that AI can do pictures very well, or picture images that look so realistic that I saw somebody do recently a wrinkled up a receipt. Now I can tell that it wasn't a real receipt just because of some of the information that wasn't on it, but I'm sure that's not that's a matter of just adding a few words to it. So I could just imagine, doctoring up photo IDs and even though there's safeguards on there, that it wouldn't surprise me if it's got all the watermarks and other things on there to show it. And um, then when you upload it, the IRS sends you an email to confirm that the submission that you've submitted something. It doesn't tell you what was submitted. It doesn't say anything about it. It just says that you've submitted something. Okay, so that's really your acknowledgement there. Now, if you use the Tax Pro online account, again, you can use both. You can remit the 2848 or the 8821, and the signature, there is actually no signature here. And I'll show you here on a few slides here but the taxpayer, you are submitting it in your online account. It goes to their individual online account and then they just accept it. And once they accept it, you have instant access to it. So therefore, you do not need an actual paper document. There is no paper for you to sign. There is no requirement for you to have an actual paper 2848 signed because they've given their authority electronically. And they're supposed to be the only one who has access to be able to log in with all the safeguards that they have to do that. Again, not to say that that's not foolproof. Now, this can only be done for currently individual accounts, although they are in the process, and I do know that they're working on the business side of this. You access this through the e-services account. Basically, if you go to irs.gov and you can click the tax pros section, or I was just out there, in fact, today, if you go to irs.gov, there's a button up in the right hand side that says sign in. And when you go to the sign in, it will actually take you to the spot where you can sign into the Tax Pro individual or business online account. Now, again, once this is approved by the taxpayer, you have it's instantly posted to the CAF unit, and you have instant access to pull transcripts. Now, the taxpayer is supposed to have a cell phone number to verify. They have to go through the process. They need either the ID.me account or a login.gov account. I think those are the only primary ways in which that can be done nowadays. Actually, I think there's a third way. Give me 1 second, and I can see what that is. They generally do it through the id.me, but login.gov, and I think there's a third way to do it, but I'm not coming up with that right offhand. Okay, now here's what it looks like when you go through to submit it to the 2848 online. You click this button to submit. If you're going to the Tax Pro online account, you're going to sign in here. Now, I've got a few extra pages here that I've added that once you come in here, that you can click to request a power of attorney or request a tax information authorization. Okay, and then when you submit it here, you'll come in here and click this view your request to see if it's been accepted there. Now, once you go into that, so you go to request a power of attorney, you'll go through here and you click this button and it will take you through some steps. So it will ask you for your CAF number and your information. Then it'll ask for the taxpayer's information. Okay, so once you go through that, then the thing that you have to be careful of, so this was actually somebody that I was dealing with, and redacted the information on this. So the key thing here is that what goes in this space for the taxpayer must match. And what they tell you is that you should look at, it says here, enter the taxpayer's information as shown on their most recent income tax return and IRS notice or IRS records. It must match IRS records in bold because it's the computers that are looking at it. Okay, so it says here, address must be one of the U.S. 50 states, district, or Columbia. Use approved abbreviations such as ST for street or AVE for avenue. So in this particular situation, one, he gave me a different address, and so so if you do not put the proper information in the fields, it won't even go to the taxpayer. They won't even approve it for them to see it. Okay, so here you need to put the full address, put this information, including the suite number, including the zip code and the city and the state. And if they have a middle initial, I recommend you use the middle initial. So this was the notice that he gave me. Once I used this, then I finally got it through to him. It took me 3 times to get it right. So one, I had the wrong address. Second, I didn't have the middle initial. And the third time, once I got all of that, I had the right address and then the right and middle initial. On the third try, it was finally accepted and he was able to accept it and I got instant access. So it does work. Now, for the individual side of things, this is how it looks like. So if they come to here, they click this button, and then what they're going to do here is this is a menu bar across the top. And on the far right is this button that says authorizations. So when they come over here and click this or hover over this area, it has this little pull down. And then they'll look for the click. It says click power of attorney and tax information authorization. So here they can review, approve, reject requests for the power of attorney. So the 2848 or 8821. When they click that button, it will take them to this page where they'll see here online authorization requests. And here they can then approve or deny that request. Okay, so it's pretty much that simple. But just so that you can see that and what that looks like for people to, so that they can see it on their end. And I highly, highly recommend this last one, putting it in the Tax Pro online account so they can accept it in their individual online account, but they have to have their own account access and be able to get in there. And if they don't, I recommend that you start telling all your clients, just like every client should have an IP PIN, every client should have be able to access their own individual online account. Now, again, a few additional things. I've kind of reiterated a few of these. Use wet signatures if you're going to actually have them sign the paper. And until there is some word that the IRS is accepting the electronic signatures, I've even had sometimes, unfortunately, where I've heard people not being able to, even with the Tax Pro online, not being able to get get information from the IRS if you call. That's why I typically don't call anymore if I can avoid it. I would rather get my power of attorney on file. I use the IRS Solution software, pull the transcripts, do the analysis. I will wait the week to 4 weeks to get at that access. And if I really need to talk to somebody, I will talk to somebody. But usually I reserve the phone calls for dealing with revenue officers or for setting up a payment plan. That's usually the only time I ever pick up the phone. Okay. But having the wet signature is if you're really going to talk to somebody at PPS or ACS. Here we just talk a little bit about that, the IRS did expand in 21, primarily due to the pandemic, the acceptance of electronic signatures, and this really goes through what that is accepted. And this is when you use the 2848. I added this slide just to say that here you need to authenticate individuals, and here's what meets that criteria. And then from the business entity perspective, here's what verifies the entity of or the validation of the person who is saying that they're a representative of that business entity. Now, the last few minutes that we have here, let's talk about revoking or withdrawing a power of attorney. So, first, let me just give you a brief definition. While revoking and withdrawing, they are synonymous terms. So if you use that in terms of talking about it with the IRS, most people will know what you're talking about. But the technical difference is taxpayers revoke, we as tax professionals withdraw. Okay, so we're going to talk about that here. Now, the taxpayer, if they want to revoke, they're supposed to write revoke across the top of the first page of the 2848 or 8821 with a current signature and date below that annotation. So what that means is they should take the page one across the top, write revoke, and then sign and it says sign and date right next to it or just below that. Okay, that's supposed to revoke that power of attorney, and then they send that into the IRS. Now, from the taxpayer or taxpayer representative perspective, you do the same thing and just in reverse, you put withdraw and then you sign and date near the top. Now, if you write revoke and sign it and date it, it should work because they're, like I said, they're synonymous return terms. I used to write revoke, but now I do withdraw. Okay, obviously it's a few extra letters, and I would use a Sharpie if you're using an actual paper return to do that. And it would look like something like this. So I would write withdraw here in the Sharpie, signature and date goes here, and then I usually write diagonally here across withdraw as well. Now, for me, I used to do it, and they used to not have any problem where I would do it here, and then on page two, I would write on because I usually had some extra spaces since I don't use the full four boxes. So I would have boxes 3 and 4, and then on the boxes 3 and 4 on the signature line, I would write withdrawal on one line, and then I would sign and date the new date of when I'm trying to withdraw that. Now, alternatively, you can request to get your CAF listing. You do this what's called a CAF 77 letter. Here's the standard letter that you can use to basically it's a FOIA request. And alternatively you can do it electronically. I'll show you that here in a second. But you send in this letter, you send a copy of your driver's license, and they will send you. Normally they will, unless you ask for it on paper, they will send it to you on a CD with a text file, and they give you a separate document that I think it's a separate document and a separate letter that will give you the code in order to access that document. And then you can go print whatever pages you want. And then what you then do is you line through all the people on that document that you want to keep, and anybody that's still showing up, you send that back to the IRS, and they are supposed to remove them from your CAF listing. Now, please note it is an all or nothing process. They don't know what you've lined through. So if you've hypothetically, if let's say you had an 1120S and you had payroll returns, and you line through the payroll returns because you're still dealing with a case on there, but you don't need you don't need that the business return, or you don't need a maybe you line through a few years and you don't need those years anymore, and you line through those, or you wanted certain years but not all the years, and you send that back, they're going to kill it all. Okay, so if you show anything that's still up for that one taxpayer, then it's all gone. And ask me how I know that one. That's a frustrating one because then now you got to go get a whole new power of attorney and put that in place to get access to everything. Now, you can go to FOIA.gov, and you ask you a few questions, and it'll take you here to have an option to choose the Internal Revenue Service. Then you go and fill out this information. So you can do this as a FOIA request for asking for client information, or if you're asking for your CAF listing. You would go through, you fill out this information, then this is basically one long continuous string. So I've given you basically the bottom pieces of that. You need to fill in here, what you're asking for. So here for me, it would be the CAF listing. Here's where you upload your ID. Then you're basically an other requester. You can't ask for a fee waiver. They're not going to give it to you. And then you can put in here the maximum number. I usually put $20 or $25. I've never had to pay in the requests I've ever done. We don't qualify for expedited processing in there. And then you just click this button and submit the request. And usually it takes somewhere between 30 to 90 days to get that. Now, if you have your Tax Pro online account and you have linked your account, then, and here's where you go through the process. You notice how it says here, link your CAF number. Click this button, put then it gives you a field where you can input your CAF number. And then what it does is it sends you a paper document. So here it takes you to this page where it says here, link your CAF number. And then you can then input that. And then once you've gotten the letter, you come back in here to then it gives you a code on that letter. And then that letter, then you can go in and actually link it to your CAF number. And every time you log in, then when you click this button here to view taxpayers, you will see all the people in which you have a 8821 authorization or a 2848 power of attorney, and you have access to that. It will show that information. Now, if you decide that you want to withdraw it, you can do that. You click on the client's name, then it'll take you. So these are little tabs here across. So it says overview is what the page that it takes you to. Click the authorizations, then you would click this 2848 button, which then takes you to this page, which shows you what you have authority for. And then if you click this box and click withdraw, then boom, you no longer have access to, just as quick as it got added if you did it with the Tax Pro online with them accepting on the individual online, then it's that quickly removed. Okay? Any questions on any of that? But it's really a simple and easy process. It can be a little frustrating until you've learned the process, but you should try to work and focus on doing everything online. That's the wave of the future. Just start getting all of your clients online, and it will benefit you. And if we all do that, then it'll benefit all of us so that when the next client comes to you with a tax problem that was created by somebody else, then they should automatically already have that information. They can log into their account, and it makes life a whole lot easier. Okay, now a few other things. Let's see here. Oh, and this is just really letting you know that um, here, this is really under the exam side, where the IRM was changed in 2018 that says fax signatures are permissible, which means that if they printed it out, signed it, and faxed it to you, and it works the same thing if they've scanned it to you, that that they can send you that wet signature. So they put pen to paper. And here it says electronically signed, printed, or stamped signatures are not acceptable. And to my knowledge, that has not been changed. Uh, I'm going to just actually look that up here real quick. Let's look at that section to make sure that that has not been changed. 55271. Where are you here? Nope, that has not changed. So that goes for the 2848 or the 8821. It says fax signatures are permissible. However, electronically signed, printed, or stamped signatures are not acceptable. Electronic signatures by representatives filed through e-services are acceptable. Okay, so if you ever have that issue, again, this is under the exam side. I don't know that I found a comparable one for the collection side, but just know that, this is some of the stuff that we're having to battle. So if you don't do it correctly, this is where I think a lot of IRS employees are hanging their hat on that if it's electronically signed, they can't accept it. Okay. And I've even had some people, even though they thought that, if it was done through the Tax Pro online, that's technically through the e-services area, and that's supposed to be acceptable. Now, let's talk about the most common reasons for rejection. It's missing a signature, taxpayer or representative. That's these are probably the most common things that, and you should have a checklist to make sure that all of these things are done, because nothing's going to be egg on your face then sending it off and get it rejected, because if it gets rejected, it goes back to the taxpayer. Now, usually you will get a copy of it too, but it goes back to the taxpayer and it makes you look silly. So make sure it's got their signature, your signature, that you both have dates. Make sure that the signatures are in sync based on what I told you before. That's why I have the taxpayer sign. I have them sign and then I sign, and that has to be within 45 days. Otherwise, if you do the other way around, then there is no limit. That the acts authorized are that acts authorized not specific says all years, all periods, all future periods. So it can't say any of those because it's going to get rejected. If you've marked the box on line 6 for the retention revocation that you included the prior power of attorney, if it's missing the representative designation, so if you're coding it with B, I think B is the CPA, A is the attorney, and C is the EA. So if you put that designation and you don't put that there, all the rest of the information, CPA, there's the CPA number, the state, the jurisdiction, all of that, those are going to get rejected. If there's the business taxpayer, so if their title is missing for the person signing, then that's the good case to get it rejected. And again, like I said, it goes back to the taxpayer to get it corrected. Now, a few other things. Third party designee. Again, remember that only is good for 1 year, and it's 1 year from the uh, due date of the filing of the return, except for 709, which expires 3 years after the date filing. Okay, this is not something that's called put on the CAF unit, but if you call the PPS, then they will be able to access that. I don't recall if ACS can do that, but if you call any other number, you can deal with the IRS on that. I've done that before. Um, And if you have multiple people in office, similar to what I said on the 8821, you can put the designee instead of it just being your name. It can be firm. Now, I heard this originally at the IRS Tax Forum. I've done it many times for many years. I've used it many times for many years. And I've heard this. This was probably 12, 13 years ago. I probably heard this. That if you put, I first heard put firm. So I just put firm. So therefore, being that the signee of the return is your name and your firm name, right? What they said was, I later had talked to somebody when I was trying to use this authority. What they said is in the future, I should put the firm and the firm name. So in my case, it was firm Daniel Hen CPA PA. So I put firm dash Daniel Hen CPA PA on that line. That means anybody in my firm can call and verify as long as they have the PIN number that you put on the return to get the information or communicate anything the IRS has. Now, here's a few of the things that you can do with that third party designee. You can give the IRS some missing information, and You can call the IRS for information about processing of a particular return, such as status of refund or payment. That's not a service I provide, and people are going to pay me extra. That's not the standard practice for me. So if I file your tax return, I'm done. If you want to know the status of your refund or payment, then you can call. If you want me to do it, that's an extra fee. You can receive copies of notices or transcripts related to that return, but only if you request it. You can respond to notices the taxpayer shared related to math errors, offset, and return preparation of that particular return. So I've gotten notices, client gave me one on a situation where we filed under the taxpayer's name, but the spouse was the one who mailed the check and included her social security number. So at the time there wasn't the proper alignment of that, and so the taxpayer started receiving notices that you owed money. So I called the IRS under using the third party designee, and I was able to get that fixed and straightened out. It was a known problem at that point in time, and I haven't seen that type of issue problem since. Now, please remember that the third-party designee does not give the designee the right to obtain information in the context of an audit, a collections case, or any other compliance activity. It only is related to that one tax return and any tax issues on that one tax return. Okay? Oral disclosure consent, we talked about that earlier. It's only good for when you're on the phone. It does not authorize a third party to represent the taxpayer before the IRS. Once you hang up, then you're done. You can request transcripts when you're on the phone, but again, remember it goes to the taxpayer, and this is not something that's recorded on the CAF number. And additionally, a designated person may include an interpreter if there's language barriers. And it is not necessary for the taxpayer to actually stay in the room. Once they've given the authority, if they needed to leave or go, then that is perfectly fine because they just need to give the oral authority. But remember, when you hang up that phone, you're done. Okay. And then taxpayers may bring other individuals when they meet with taxpayer advocate, but their presence does not establish an implied consent. So they do have to ask the taxpayer if they're with you, then they have to ask the taxpayer that it's okay if you don't have a power of attorney in your hand that gives you that authority. Now, please note for all of you, those of you, David in Hawaii, Bob in Arizona, Carlton, you're in Texas, so you don't have to worry about it, but you're in an area where you're close to Louisiana, Oklahoma, and a few other states, so it's easy for you to have clients in those states. But wherever you are dealing with, don't forget that if you have a federal issue, they are likely to have a state issue. So one, many states have their own form for power of attorney. Most of them don't accept the federal form, but you need to make sure you have that and make sure you know what those rules are because statute limitations are different in many states. The whether or not they have a payment plan or the offer and compromise equivalent or a CNC equivalent, some states do, but some states don't. So please make sure you look to that particular aspect. And lastly, here are some additional resources for you to research. This is all some of the areas where I've gotten a lot of the information from and from experience there. So here are some of the resources where you can look at some of this. And at the end of the day, make sure all the information is accurate before you submit it. If you have special situations, make sure that you attach whatever's needed to be attached. And always have the client review and sign that form before you get it signed. And once it's signed, make sure that everything is there. Okay, that everything is accurate and everything that you need, including the periods, the returns, the access, so that you don't have to make the request again because it's pain enough a neck enough to get somebody to sign it the first time and then trying to get them sign it a second time because you need to add more years, you had to need add more forms. Although sometimes you can't avoid it, but just try to be all inclusive as you can. Now, as I mentioned to you, this class is a sweeping overview. We've barely touched the tip of the iceberg. And if you know of anything about the iceberg, you know that 2/3 of it is typically below the surface. So that there's so much more, so much deeper we can go into a lot of the classes I've told you throughout this here, some of the various other classes that we teach in regards to that. So let me ask you a question. Would it be okay if I show you an offer to join a community to help you save time, earn more money, and gain the confidence you need to handle IRS representation cases? And if so, would you please put yes or yes into the chat so we can go ahead and move on? Okay, great. Thank you guys. I appreciate that. So what I want to do is introduce you to the Tax Resolution Academy. Now, the first thing I want to point out in the Tax Resolution Academy is you have access to our CTR, the Certified Taxpayer Representative Certification Program. And what that means is that we have 21 CPE classes that are, if you take them, then you demonstrate knowledge of 5 cases. So basically, you send us redacted information that you've handled 5 cases. And then you take a 50-question multiple choice exam that is actually fairly simple in terms of that. It's not overly complicated. And if you've taken these 21 classes, you'll know all the answers. And you have to maintain your membership in the Tax Resolution Academy. Now, here on the screen are 25 classes available at our foundations level. And all the classes in green are the 21 classes in which you would need to take to be eligible. So this class, CTR 100, Intro to IRS Collections Representation, is one of those 21 classes. Now, we also offer another 25 classes at our intermediate level, and here we cover some business, trust fund stuff. We talk about the lien certificates here, partial pay, and then we do have a bunch of exam-related classes that you can take. Now, we also give you access to our generally once a week office hours call. They're generally Fridays at 1 p.m. Our next one will be this coming Friday. Then we do at least a once per month case study session. So if you have a case, you've filled out the forms and you're just not sure and it's just you in the office, you want a second set of eyes, send me the redacted information and we go through that. We do this in a session, we record that, and I make that available for you and other members to be able to see on how to handle and analyze certain aspects of cases. Now we give you, we list all of the events. So like this class was listed for our members, and what I've got, I think 3 or 4 members that are here that they come here and click this button and they get the behind the scenes Zoom link so they don't have to pay anything further, like those of you that paid through Eventbrite to be here for this particular class. Now this class is a reduced cost class, but normally most of the rest of our classes are $59 a piece. You also get access to our supportive community. We use a platform currently called Mighty Networks, and Mighty Networks allows for the members to post just like a Facebook post or Facebook community. I say it's like Facebook, but it's not because you don't have all the other distractions of Facebook. It's a self-contained community. You come in here, you ask your question, and we have a lot of practitioners that are out there that are helpful and want to help you with your cases. So who's the Tax Resolution Academy not for? It's not for you if you're lazy, you don't want to deal with the IRS, you hate people and their problems, you're unwilling to invest time and money in your professional growth, you don't want to make any more money than you already do, and if you have a fixed mindset, resistant to change, or you easily give up when faced with challenges. So that makes membership in the Tax Resolution Academy for you if you want to make more money from your tax practice. You're an excellent tax pro. You love helping people solve their IRS problems. You have a growth mindset and a passion for continual professional development. You want a real system for processing tax resolution cases, and you desire to generate a better and bigger cash flow from your tax practice. Now you have 2 choices. Your first choice is do nothing, go about life the same as usual, nothing ventured, nothing gained. And that's perfectly fine. Okay, if you think that you're not going to handle cases or you know how to handle the cases, you don't need the support, then fine. You know where to find me if you do have the occasional question that you can't answer. Your other choice is make a small investment today compared to all the value you're going to get in return, get support to get the education, earn more money, and give it a shot. So here's what you're going to get as part of the Tax Resolution Academy. So you get all of these things here, many of what I listed already earlier, but you also get access to marketing templates, lead magnets, instructional videos on marketing and sales in various different aspects. You get access to the office hours call, the case study class that I mentioned, the membership portal. You get access to our template library, which includes engagement letters, contact letters. I've got disengagement letters. There's over 100 hours of CPE available there. You also get access. This is a newer member benefit that I established, about 5 months ago. Lamber's Continuing Education, All Access Pass. You only get that while you are a member of the Tax Resolution Academy. They have over 200 classes of other classes. So if you want to learn about hobby loss rules or 1031 exchanges, those kinds of things that we don't teach, they have access to that, and you will have access as being a member. You get access to you get a copy of all four of these little books, and I would recommend you start here with How to Build $1 Million Tax Resolution Firm. This was written by my former co-founder Jason Bowman of the Tax Resolution Academy. And then read The Hidden Profits in Your Tax Practice is a book that I put together based on a class that Jason and I originally taught. And then you also get access to the Tax Resolution Systems book, which this book alone is about almost 300 pages of checklists and other tools to help you handle a tax resolution practice. Now, you get access to this, and I'm going to put this link here into the chat for you guys to access to make it easier for you. But you get access to this today for $199.99. You get 30 days free access to the Academy and all the materials. We'll mail you a package with all of these different things. You can cancel at any time. There are no contracts. There is one option that if you do decide to join, you can join for if you paid for 10 months, you get 2 months free. So if you go to this link, you have two choices. So you can pay monthly or you can pay for the annual. Now, there is a fast action bonus. Today, if you join by midnight tonight, I will give you access to the audit protection plan and IRS account monitoring service. It's a toolkit that we sell for $495 on our website, and it gives you materials in which you can go monetize. And this is some additional monetization of your practice or because resolution cases are basically one and done. And so you always have to go get that next case. Account monitoring is something on how you can make it a regular recurring, almost membership type income on a case. Now, the question I have here is how many cases does it take to break even? So if you pay the $200 a month and you stay for a year, that's $2,400 a year. Let's say you pay $1,500 to join some resolution software as well on top of that, which I would recommend. So you're paying $3,900. Let's call it $4,000. You can easily get $3,000 in back tax returns. And it's going to depend on what you charge, but that could be anywhere from 3 to 6 returns. You can get $3,000 on a relatively easier collections case. That's just one case. And if you wanted to get $5,000 of monthly regular revenue, that's anywhere from 1 to 3 cases, usually at the most. And that's not even if you're charging that much for those cases. Okay. Now, if all this did was get you a new source of revenue that naturally fits with what you're already doing, wouldn't that be worth it? If all this did was give you the opportunity to learn a new skill that is not a commodity service, would it be worth it? Okay. And if all this did was reduce your time in having access to materials that you do not have to create on your own, because a lot of stuff that I gave you in that list, would it be worth it to join the Tax Resolution Academy? Now, if you have any questions, feel free to ask. Okay. Bob says I sent one via the IRS upload non-tax pro method. Okay. You did it on the 28th and have not gotten it, so that's already been a week. So yeah, maybe you can report back to me when you find that one out. But I would say 2 weeks is still pretty the standard. in terms of that. A minimum of 2 weeks. I've had recently as quickly as a week, like literally 7, 8 days. There were a few years ago that they were literally doing them and having access the next day, which was great. But that's again, this is another reason why if you have the ability to use the Tax Pro online area to do that, I would recommend doing that. So with that, you guys have a great rest of your day, a great rest of your week. Uh, remember, office hours is tomorrow at 1 p.m. Eastern, and I hope to see you guys there. Have a great day, guys.